Good afternoon, everybody, and welcome to the annual Paul M. Van Arsdell Jr. Memorial Lecture on Litigation and the Legal Profession. Let me say a few words about the person for whom this lecture is named. A triple Illini, that is someone who has 3 degrees from the University of Illini, for those of you who may not know. Paul Van Arsdell Jr. was a partner at Latham & Watkins, a premier law firm based in Los Angeles, but with a presence throughout the nation in the Chicago office. He was an outstanding litigator, especially in the area of consumer law, and was regarded by his colleagues as an invaluable counselor and mentor to other lawyers. He became the youngest ever head of the firm's finance committee, and as I'm sure you can imagine at big law firms, the finance committee is a very important committee. A demonstration of the deep respect his peers had for his talents and his character. The Van Arsdell family, the Latham & Watkins firm, and many of Paul's friends, colleagues, and clients endowed this memorial lecture series to promote thoughtful discussion about litigation, dispute resolution systems, and how best to maintain the highest ethical ideals of the legal profession. Today, we are delighted to welcome Ms. Kristen Clarke to the College of Law to deliver the 2017 Van Arsdell Memorial Lecture. As President and Executive Director of the Lawyers Committee for Civil Rights Under Law, which is often simply referred to as the Lawyers Committee, Ms. Clarke leads one of the country's leading civil rights organizations, invariably on the forefront of the pursuit of equal justice for all. Throughout her career, she has focused on making democracy a reality rather than just an ideal, by combating, among other injustices, discrimination faced by African Americans and other marginalized communities. Her resume of public sector and public interest work is as impressive as any I have ever seen, literally. She formerly served as the head of the Civil Rights Bureau for the New York State Attorney General's office, where she led broad civil rights enforcement on criminal justice matters, education and housing discrimination, fair lending, voting rights, immigrants' rights, gender equality, disability rights, reproductive access, and LGBT equality. Under her leadership, the Bureau secured landmark agreements with banks to eliminate unlawful redlining practices, with employers to address barriers to re-entry for people with criminal backgrounds, with police departments on reforms to policies and practices, with major retailers on racial profiling of customers, and with one of the country's largest school districts concerning issues relating to the so-called school-to-prison pipeline. Ms. Clarke also spent several years at the NAACP Legal Defense and Education Fund, known often as LDF, where she helped lead the organization in the areas of voting rights and election law. Prior to joining LDF, she worked at the U.S. Department of Justice in the Civil Rights Division in Washington, D.C., where she served as a prosecutor in the criminal section, handling police misconduct, police brutality, hate crimes, and human trafficking cases. Ms. Clarke speaks and writes regularly on issues concerning race, law, and justice for both professional and lay audiences. She is the author of numerous articles and books, and has served as a lecturer in law at the Columbia University School of Law, her alma mater, where she received her JD after having received her bachelor's degree from Harvard. We are exceptionally fortunate and thankful that she could be with us to speak here today, and so please join me in extending her a warm welcome.
Good afternoon. I'm really proud to be here today, and I want to first start off by thanking Dean Amar and Professor Nicholas Sharp for the kind introduction and for the very generous invitation to speak today and present the Paul Van Arsdell Lecture. I was reflecting, Dean, on the underlying goals of the lecture, part of which is to promote the highest ethical standards of the profession. And I very much believe that being attuned to and being able to identify civil rights problems that are happening across our country is part and parcel of demonstrating the highest ethical standards when it comes to being a lawyer and practicing the legal profession. So really looking forward to spending an hour with you today. I also want to note that I think you all are tremendously fortunate to have Professor Sharp as a part of this rich community. I've very much enjoyed following and watching her career and following and watching the career of her husband and partner, Professor Jamel Sharp. Together they are quite an intellectual force, and I think you all are just incredibly lucky to have this team as part of the faculty community here. Before I start today, I want to share a little bit about the history underlying the Lawyers Committee for Civil Rights Under Law. The Lawyers Committee was founded in 1963 at the behest of President John F. Kennedy during the heyday of the Civil Rights Movement. Kennedy convened a meeting at the White House that was focused on lawyers in the private bar. The feeling in the country at that time was that private lawyers were not doing enough to engage in the civil rights fight. There were about 240 lawyers who heeded the call and attended a meeting at the White House, and his charge to them was to figure out how they could engage in the civil rights fight. Many of them ended up going back to their communities, their home communities, they rolled up their sleeves, and they tried to figure out how they could use their law license to come to the aid of victims of discrimination. And some of the first cases that many of those lawyers undertook were cases to protect and safeguard the First Amendment rights of people engaged in peaceful protest and demonstration. I enjoy sharing this history for a number of reasons. It very much defines the DNA of our civil rights organization. We are an organization that carries out our civil rights work standing shoulder to shoulder with members of the private bar. We have a board that's comprised of about 200 lawyers, leaders in the profession, who bring to bear the resources of their firm to help us investigate and prosecute our civil rights cases. But secondly, I also find this history very relevant to the moment that we're in right now. We're very much in a moment where we need all hands on deck in the civil rights fight, and in fact work to protect the First Amendment rights of people engaged in peaceful demonstration remains just as critical today, as we're seeing with the Take a Knee movement and as we're seeing with student athletes who are choosing to shine a spotlight on racial injustice and police brutality. So we've come a long way, but we've still got a long way to go. So with that framing, let me move to the focus of my presentation today. The world has changed a great deal over the course of the past year. Civil rights are most certainly under attack in virtually every respect. We've seen this U.S. Department of Justice, under the leadership of Attorney General Jeff Sessions, exhibit great hostility towards protecting the civil rights of vulnerable communities. In just 9 short months, this Justice Department has brought enforcement work to tackle police misconduct to a virtual grinding halt. He's eliminated protections for transgender students. He's reignited the war on drugs by encouraging federal prosecutors to impose harsh sentences on low-level offenders. He eliminated a directive that would have phased out the use of private prisons for federal inmates. He instituted a discriminatory Muslim ban and has done so 3 times now. He's reversed positions in active civil rights litigation. He submitted an amicus brief to the U.S. Supreme Court defending a baker who refused to provide services to a same-sex couple. And we are starting to see the early signs of an open assault on affirmative action efforts at colleges and universities. But it's this administration's efforts to actively promote voter suppression that I would like to talk about today, with a focus on the general attacks that we're seeing on voting rights across the country. So to frame this, I want to take a step back to 2013. In 2013, the United States Supreme Court issued a critical ruling in a case called Shelby County, Alabama v. Holder. This ruling is one of the most critical civil rights cases to emerge out of the Supreme Court in recent time, and it's one that got the heart of the Voting Rights Act, one of our nation's most important federal civil rights laws. The Voting Rights Act was passed in 1965 following peaceful demonstrations of civil rights demonstrators who were focused on eliminating Jim Crow-era restrictions on the right to vote. From literacy tests to poll taxes to understanding clauses, there were efforts underway to deny African Americans access to the ballot box. But a turning point in those events came following a march from Selma to Montgomery, Alabama. In a day now known as Bloody Sunday, peaceful demonstrators, including the Honorable John Lewis, were viciously beaten and assaulted as they crossed the Edmund Pettus Bridge in Selma. The images of young people being beaten with billy clubs and attacked by dogs were transmitted across black and white TV screens across the globe and really put pressure on President Lyndon B. Johnson to act. He urged Congress to move forward with passage of the Voting Rights Act, and it's a remarkable piece of civil rights legislation that contains a number of important provisions. Chief among them was the heart of the act known as the Section 5 preclearance provision. This part of the act required certain parts of the country, like Alabama and other parts of the South with very long and egregious histories of voting discrimination, to obtain federal review of voting changes before they could be put into effect. It applied to small voting changes, such as a decision to move a polling place to a large and complex voting decision, such as a new redistricting plan for a community. And through the federal review process, Justice Department officials or the D.C. District Court, which is empowered to handle this review process, blocked hundreds. This review process literally blocked hundreds of discriminatory voting laws and changes that would have otherwise gone into effect. This unique part of the Voting Rights Act was not permanent. It required that Congress periodically reconvene to determine whether the strong medicine of the Section 5 review process remained necessary. When Congress last met to determine whether or not Section 5 was still needed in 2006, there were a number of members of Congress who felt that discrimination was a thing of the past and that we no longer needed Section 5 in our democracy. But by the end, we saw Congress really doing a careful job studying the problem of voting discrimination in our country. They held over a dozen hearings. They heard from more than 100 witnesses on both sides of the aisle. And they amassed an extensive record that made plain voting discrimination remained alive and well across the country, and that Section 5 was doing really important work to block some, not all, but much of that discrimination. The vote in the House was 390 to 33, and in the Senate, 98 to 0. But before the ink was dry on the bill, we started to see almost immediately a coordinated campaign to tear down the Voting Rights Act. About 6 days after President George Bush signed the bill into law, the first constitutional challenge was filed. It was a case brought by a small utility district in Texas that basically alleged that Congress exceeded its power by renewing Section 5 and argued that discrimination was no longer an ill that we were living with. Ultimately, Justice Roberts issued a ruling for the court that dodged the core question in the case. He invoked the doctrine of constitutional avoidance and found more narrow statutory grounds to resolve the case, leaving the law intact, but subsequent constitutional challenges followed. So that brings us to the Shelby County case that I mentioned a moment ago. Now, it's worth noting that the Shelby County case emerges from Alabama, and you'll recall this is the birthplace of the Voting Rights Act, essentially, and now we see Alabama emerging as the place that put the death knell in the act. In the Shelby decision, the Supreme Court issued a ruling that brought the Section 5 review process to a grinding halt. At issue in that case was the Section 5 preclearance provision, but also another provision that determined the 16 or so jurisdictions around the country that were subject to this federal review process. The court found that that coverage provision was unconstitutional and basically put the ball in Congress's court to come up with an updated formula, an updated coverage provision. But 3 years have passed and Congress has failed to act, and the Section 5 review process is no longer with us. As a result, we've started to see states and localities moving forward at almost lightning speed with new restrictions and voter suppression measures that make it harder for ordinary Americans to vote. But many of the voter suppression measures that we're seeing are ones that fall more heavily on African Americans, Latinos, the elderly, students, and other vulnerable communities. Now, one state that moved forward at lightning speed was the state of Texas. On the day that the Supreme Court issued the Shelby County decision, they announced that they were moving forward with a voter ID law that had been previously blocked by the Section 5 review process. I'm going to ask for a show of hands. How many of you have a driver's license or passport? Yeah. Now, voter ID laws don't impact people who are mobile, the middle class. Voter ID laws impact people on the margins in our country. People who are poor, people who don't fly, people who rely on public transportation. The poorest of the poor are the ones who are negatively impacted by these voter ID laws. On the day that Texas put its voter ID law into effect, there were 600,000 registered voters, people who had been actively registering in the state of Texas, who were essentially disenfranchised by the law. This represents about 4.5% of the population in Texas. People on the margins, people who are invisible, but people who deserve the right to vote and who deserve a voice in our democracy. Now, we've been fighting this case with the Justice Department, who had been standing shoulder to shoulder with us for the first 3 years of the litigation. The Justice Department actually put forth experts in the case who helped to establish the discriminatory effect of the law. There were more than a dozen attorneys who helped handle the case. But things started to change on Inauguration Day. On the afternoon after the president was sworn in, the DOJ moved to delay a critical hearing in the case and very soon thereafter abandoned the position that they were taking in the case, leaving civil rights groups to continue the battle on its own. There are about 5 courts now that have found Texas's voter ID law to have a discriminatory effect or have pronounced the law to have been adopted with a discriminatory purpose, but Texas continues to fight this case. They've expended about $4 million in taxpayer dollars defending their ID law, and sadly, this, I think, provides strong evidence of Texas being truly recalcitrant and hostile when it comes to voting rights. Let me move on, though, to some of the other voting rights struggles that we're faced with today. This spring, the president launched a so-called Presidential Commission on Election Integrity. This commission is by far one of the most dangerous efforts that we have seen by this administration when it comes to curtailing voting rights. The commission was founded largely to help substantiate the president's false claims that close to 3 million people voted illegally in the 2016 election. The commission claims that it aims to study in part the problems of vote fraud across the country. But we know that vote fraud is not a widespread problem. We know that 3 million people did not vote fraudulently in the election, and that the true goal of this commission is to lay the groundwork to promote voter suppression efforts across the country. So how do we know this? Well, the president's choice of commissioners makes the agenda here fully transparent. The president has appointed individuals who are notorious for promoting voter suppression. U.S. Kansas Secretary of State in Kansas, Chris Kobach, is someone who has made a career out of pushing anti-immigrant and xenophobic policies. He's pushed a proof of citizenship requirement on people seeking to register to vote in Kansas, a requirement that ended up locking out about 1 in 7 people who have tried to register to vote unsuccessfully. He's been appointed as the co-chair for this commission. Alongside Chris Kobach are other appointees, including Christian Adams and Hans von Spakovsky, 2 individuals who have also made a career out of promoting voter suppression and did so during the Bush years, during my time at the Justice Department. Another person serving on the commission is Ken Blackwell, former Secretary of State of Ohio, who gained notoriety for rejecting thousands of voter registration forms that he deemed not printed on the right paper stock or paper of the right weight. So the people leading this commission are ones known widely to promote voter suppression and the ones who are driving this effort. This summer, the commission made an unprecedented request for voter data. They issued a request to state election officials across the country seeking data on every voter across our country. They seek full first and last names, middle names, date of births, last 4 of your social, political party, your voting history, your military status, among other things. It's truly an unprecedented data request, and it really appears to be a big brother attempt to amass data on Americans across our country. Election officials from 7 states have reported that numerous voters are calling and requesting that they be removed from the rolls because they seek to avoid any entanglement with this commission's activities. We have brought suit against the administration to bring transparency to the commission's efforts. In the context of our litigation, we've learned some things. A number of the commissioners are using private email addresses to carry out commission activity, and the idea of private voter data being exchanged across private email accounts, I think, is very disconcerting. They've failed to disclose a number of documents and materials that they are relying on in advance of public meetings. This violates a federal law known as the Federal Advisory Committee Act, and they're not providing a meaningful opportunity for the public to participate in their meetings and activities. At the end of the day, we see the commission as a tool for promoting and incentivizing voter suppression efforts across the country. Well, let me move now to yet another challenge that we're faced today in the voting rights context, and that concerns partisan gerrymandering and racial gerrymandering. Partisan gerrymandering is when elected officials manipulate boundary lines to achieve a certain political objective. And racial gerrymandering, likewise, is when elected officials use race to achieve a racially motivated objective. And both of these practices are threats to democracy that we're still wrestling with today. 2 weeks ago, the Supreme Court opened this term by hearing an important case concerning partisan gerrymandering, a case called Gill versus Whitford. This is one of the most important cases the Supreme Court will hear this term, and the question before the court concerns what constitutes unconstitutional gerrymandering. The case should provide a long overdue response to a question of overarching importance to the future of our democracy. When does extreme partisan gerrymandering cross the line, and when should it be subject to judicial review? On the one hand, virtually every Supreme Court justice who's offered an opinion on this issue, ranging from the late Justice Scalia to Justice Ginsburg, has stated that extreme partisan gerrymandering is incompatible with democratic principles. In jurisdictions nationwide, we've seen legislators draw legislative maps so that they can choose their votes instead of having the voters being able to choose their representatives. The facts before the court in this case arise out of a case that arose in Wisconsin. In 2012 in Wisconsin, the Republican Party received a 48.6% of the statewide vote share for assembly candidates, but that translated into a win of 60 of the 99 seats in the Wisconsin Assembly. In 2014, the Republican Party received 52% of the statewide vote share, and that translated into a win of 63 of 99 seats. Now, partisan gerrymandering is an offense committed by both sides of the political aisle. We've not seen the Supreme Court pronounce a rule making clear when lawmakers have crossed the line, but the hope is that this case will provide a moment for the court to do so, and this is especially critical on the heels of the upcoming 2020 round of redistricting. We filed an amicus brief in this case to make clear that too often minority voters are the victims of partisan gerrymandering, particularly in states where their allegiance to one party may be well known and where they can be identified from the voter rolls. While there are other parts of the Voting Rights Act that can be used to challenge racial gerrymandering and partisan gerrymandering when they rear their head, it's difficult to do so. So this case will have important consequences and provide clarity for people who are seeking to ensure that we have fair maps when it comes to redistricting at every level in our democracy. I'll also note that there's bipartisan support for addressing partisan gerrymandering. In fact, after the oral argument 2 weeks ago, I joined Arnold Schwarzenegger for a rally outside the Supreme Court. He has been a strong and vocal opponent calling for termination of gerrymandering. Other supporters include Governor Kasich, Senator John McCain, former Senator Olympia Snowe, and others. So there's strong bipartisan support for addressing this crisis. Yet another issue that we are faced with today are voter purge programs. These are efforts that we see in many parts of the country where election officials claim that they're, quote, cleaning up the registration rolls, but ultimately they're removing and striking legitimately registered voters from the rolls. There's another case that the Supreme Court will hear this term, a case called Husted versus A. Philip Randolph Institute. And this case involves Ohio's aggressive voter purge program that disenfranchised tens of thousands of voters in that state, including 70,000 voters in just 4 counties alone. We believe that Ohio's voter purge program violates another voting rights law called the National Voter Registration Act, which has established clear rules on when officials can and can't remove voters from the rolls. Here, Ohio's arguing for a use and lose rule and essentially is striking voters from the rolls if they've not voted in for 2 elections. We believe that this violates the letter of the NVRA, and we're hopeful that the court will announce a ruling that will help safeguard voting rights for many Americans who often turn out on Election Day to find that they'd been removed without their knowledge or without notice. The influence of Russia on U.S. elections. I'm not going to say much about this because I think that this is an area that requires close and careful analysis. I think that there is a lot that is unknown. For civil rights organizations that are deeply engaged in this work, it's discouraging to see precious federal resources being used on activities like the Election Integrity Commission when we have real and credible threats like Russian propaganda and other efforts that appear to demonstrate clear meddling in the integrity of our elections. So where does that leave us? I think that today in 2017, it's very clear that the right to vote is under attack, and these attacks matter. We have one of the lowest voter participation and turnout rates when you compare the U.S. to other modern democracies around the globe. We should be championing reforms and efforts that make it easier for ordinary Americans to vote. Reforms such as same-day registration that would allow people to register and vote on Election Day. We should be opening up early registration opportunities for 16 and 17-year-olds. We should be thinking about automatic voter registration, and I'll note that Illinois actually just became the 10th state to institute automatic voter registration. Automatic voter registration is essentially a reform that says that when people go and engaged with a DMV or with a Secretary of State's office or other state agency and provide information that confirms their identity, their address, their date of birth, that information should be automatically transferred to a sister election official unless somebody opts out, so that those individuals can be automatically added to our registration rolls. And we need more states across the country that are following Illinois' lead and taking action to reach not yet registered Americans across our country. We also need to gear up for the 2020 round of redistricting. This is going to be the first redistricting cycle in more than 5 decades without the full protections of the Voting Rights Act in place. We're hopeful that Congress will restore the Voting Rights Act, that the Supreme Court will announce rules defining what constitutes unlawful and unconstitutional partisan gerrymandering, that will have citizens who are engaged and active participants in their redistricting process. But this redistricting cycle, it could be one where we see a lot of mischief, where we could see a lot of rollbacks on fragile progress unless the courts intervene and provide clarity, and unless Congress moves now to restore the Voting Rights Act to its full vitality. At the end of the day, the right to vote is truly the foundation of American democracy. It's the right from which all other civil rights are derived, and it's a right worth fighting for. I'll just close out by observing that many of you are attending law school during a most interesting time. You are attending law school at a time in which we are seeing and experiencing grave threats to democracy, and this is a moment where we're seeing grave efforts to turn the clock back on fragile progress that has been made. There is urgent work that lies ahead, and you all stand to play an important role in this struggle. The courts have always proven to be a critical forum for safeguarding civil rights and a place to champion for equal justice under law for all. And my hope is to see many of you engaged in that fight for justice and to help us in the work that's underway to help achieve a more perfect union someday. Thank you so much.